there. I'm so happy to be here, not just because I'm out of the blizzard in New York. I want to thank the ACLU of Colorado for inviting me to come and to come at this timely time to your state. I want to thank Kevin Paul, who is now here, and his partners for sponsoring today. It warms my heart tremendously always to visit the states that I have had the pleasure of suing during my time at the ACLU. And my partners in crime, Mark Silverstein, Kevin Paul, and I think soon to be Ed Rainier here when we sued over an abortion restriction. And we did get attorney's fees, so that makes it all the more special to come back here. But that's just one piece of the extraordinary, work that I know that this affiliate is doing. I mean, I come here and I know that this is the place that defeated the Personhood Amendment for two times. And I agree with what Nathan said. We sit in the national office and other people call and we say, Colorado did it. And it'll cost you guys a lot of money, so you really shouldn't do this, to try to use your example to defeat and discourage other people from doing the same. I know you're on the verge of passing a measure to protect civil unions, which is just fantastic. And I also feel buoyed by the fact that I think you're about to do it without any exemptions for religious discrimination, which is all the more. When I left, some of the staff came up to me and said, "You're going to Colorado? Like, that affiliate is just rocking." So thank you to everybody who's with the affiliate, and thank you to all of you, because all of you make all of this work possible. Everything you do makes it possible, so thanks so much. So today I want to talk about the topic, devotion or discrimination. And really to talk about the different ways what we see in the country is a real rash, I could call it a storm coming from New York, but a storm of instances where institutions and individuals are arguing that they should be exempt from a law because that law would require them to engage in conduct that violates their religious beliefs. Right now there's over 40 cases all across the country with different institutions ranging from the University of Notre Dame to a chain of arts and crafts stores called Hobby Lobby to manufacturing companies, all bringing suit challenging the new requirement that employers must include as part of their insurance plan for employees coverage for contraception. And they're arguing that this violates their religious freedoms. We see, and you all know it probably here in Colorado, you see, a bakery turning away a couple because it's a same-sex couple seeking a cake to mark their relationship. We see inns all across the country doing the same. We're seeing a spate of cases of Christian schools which have fired women because the women have gotten pregnant while they were not married, or because they sought to avail themselves of assisted reproductive technologies, IVF and other things, in order to get pregnant in violation of church doctrine. And we're also seeing, we've seen a case, it's my personal favorite, which means it's bad, of nurses bringing a lawsuit to say that they shouldn't even have to take blood pressure of a patient where that patient has come in for an abortion. Again, these are all in the names of religion. So these cases, they're incredibly important, right? They're important in part because, as you see from the papers, at least I bet the Denver Post isn't different, but when you see it in the New York Times, there's a national conversation happening right now about what religious liberty means, with these cases and these kinds of bills providing the vehicle for that conversation. And so it provokes the questions, right? Sort of some of them kind of obvious in terms of what are the limits of religious liberty? Can we as a society require that people engage in conduct that violates their religious liberty? And do you have the right, as part of your religious liberty, to impose your views on others, as in your diverse workforce, or as in the people who walk through your doors seeking services? And where did those lines cut? So today I want to talk about those questions, and I want to talk about them less by talking about the law, and I'm happy in question and answers to talk about the law, but I sort of think the law is the least interesting piece of this, despite the cases, some of which will go to the Supreme Court. But I want to talk about some of the challenges or some of the questions that I hear and sort of how we at the ACLU have been thinking about this issue as we embark in this conversation. First of all, I just want to go back to what's going on, because I can't really get over it. 40 cases, I think it's actually 45, maybe it's 46 cases blanketing the country challenging a requirement for contraception in 2012, right? There's so many things in that sentence that make me crazy. But it is completely unusual to have, if you're not a lawyer, the idea that there's 45 cases across the country about one law is unusual. And I thought, well, maybe I just have lost touch. So I went to my boss and I said to Steve Shapiro, who's been mentioned, is this unusual? And he said, yes. And I now have been quoted at a fancy conference of having said, it's just bananas. But I really think it's a form of social protest. I think in many instances, particularly the cases that are being brought by the Catholic institutions, to some degree it's a form of social protest. To some degree it's a way of putting pressure on the Obama administration. And to some degree it's almost, I think, a religious act, as in, if I ultimately must comply, I can tell myself I did everything humanly possible to show that I protested and went as far as I could. I've been at the ACLU for 20 years. I've never seen a state like this recent rash of cases coming out of the religious schools in which women are being fired for being pregnant or for using assisted technologies. I don't know why it's happening right now. The only thing I can think of is it's happening right now either because we are noticing them, or it's happening right now because some of these institutions are trying to take advantage of a moment and join the conversation to show the myriad different ways in which the institutions feel that they're being pressured to violate rights. And then the instances of what we call public accommodations, inns, the bakeries, other services. We're seeing stories like that, what you have in Colorado happening all around the country. We're also seeing what you have here in Colorado, Catholic Charities saying that they shouldn't have to place children with couples who are either unmarried or LGBT couples. That's happening all around. And then in the context of the Supreme Court case, Nathan mentioned the Windsor case. This is a case in the United States Supreme Court. It's one of the cases saying around marriage for same-sex couples. There's just a slew of briefs filed by different religious entities saying, if you ever, you Supreme Court, engage in the business of according recognition to relationships for same-sex couples, the sky could fall. And it could fall in a whole bunch of different ways, because if marriages for same-sex couples were required, why that might mean that my hospital, for example, might have to provide benefits to the marriages of same-sex couples the same way I provide benefits to heterosexual couples. Or in my religious university, what are we going to do in our married student housing? We will face a whole series of issues and subtext, more lawsuits. And then, as we all know, if you're tracking the U.S. conference, the United States Conference of Catholic Bishops, they're having a field day. I don't really know what Obama was thinking when he made these accommodations, as if he thought this was going to satisfy any of these adversaries. But the bishops have a very serious campaign to try to educate people about what they perceive as the dramatic threat to religious liberty happening in the country right now. And they've had a series of Fortnight for Freedoms and other initiatives, and they have a pretty interesting letter that they've put out sort of explaining the position and tapping into really martyrs in some sense. A pretty interesting historical document. So there you have it, the pitched battle, as I say. So one question is, so why? Why now? Why 2012, 11, 2010, whatever the sort of beginning of this wave is? And I think it's not a surprise in any sense. I think to some degree, we've seen this kind of battle, or we've seen this particular challenge, this particular bumping, whenever we've had significant moments of social progress, for significant moments of change. And I think back to your quote about change is hard. Change can be unsettling in a whole bunch of different kinds of ways. So in the civil rights era, even when the successes were really inevitable. So we saw this. So in the 1960s, one of my favorite cases, I think it might be the second time I've said that today, but still, it's true. One of my favorite cases is a case brought by Piggy Park. Piggy Park was a franchise of barbecue restaurants in South Carolina. And Piggy Park got sued because they refused to serve African Americans. And Piggy Park came in and said, well, it's consistent with our faith. God teaches us that the races shall be separate. And the good news is by the time this case gets into the court systems, we have laws prohibiting this discrimination. The courts do not indulge and do not grant an exemption for Piggy Park and its restaurants to say that your religious faith entitles you to do this. In Loving versus Virginia is a case challenging rules that said blacks and whites couldn't marry. And in that case, religion was also invoked, but what was interesting there is that the lower court says, you know, Almighty God did not intend for the races to mix. Fortunately, that was overturned. But again, this is religion being invoked. And as late as the 1980s, in a case involving Bob Jones University is challenged because it has a discriminatory admissions policy. Never figured out exactly how they did it, but they didn't want to admit students who either engaged in interracial dating or believed in interracial dating because, again, the races shall not mix. That case goes all the way to the United States Supreme Court, and the United States Supreme Court also rejects the religious liberty argument as to why they should be allowed to engage in this practice. Around the same time, we also saw religious schools paying married women less than married men. They got sued. And they invoked religion to say that consistent with my faith, we pay men more than women because men are the heads of households under our faith, and they also lost. So the good news about this story, about today's story, is I think today's story is a sign of progress. You wouldn't have a pitched battle if we weren't making progress. There wouldn't be a pitched battle of somebody arguing for an exemption if there weren't going to be a rule changing things, right? So if there's no rule that you can't discriminate in your bakery, or that you can't discriminate in your inn against somebody based on their being lesbian or gay, bisexual, or transgender, then you don't have to have an exemption. It's a sign that there's enough, that this is a turning point, this is a tipping point in terms of LGBT rights. And I have to say the sentence, it's a sign of progress that we're getting contraception in 2012. Okay, I can't help it. I'm really angry it's taken this long. But better late than never. So it's a sign of progress that there can be 45 cases around the country challenging this. So it is what I refer to as Plan B. Plan A is, don't let that change happen. That change is against our values, against our principles. Don't let society go in these directions. Plan B is, oh my gosh, here it comes. Don't impose it over here. So now I just want to talk about I want to focus briefly on the two different kinds of cases that are most active right now. The public accommodations cases, and that's the inns and that's like legal gobbledygook for, have you open your doors, you are a public accommodation, you accommodate the public in your inn or your restaurant or your store, and then the contraception cases. And what's interesting about these cases to me right now in this national conversation is that there are many people who are sympathetic to the underlying causes, sympathetic to the notion of advancing LGBT rights, sympathetic to the notion that women should have access to contraception, who still say, but shucks, Louise, like, this is, people have genuine, serious religious opposition, and can't we carve out so as to avoid this conflict? Shouldn't we carve out so as to avoid this conflict in the face of those serious religious objections? Isn't there a way? And as you can imagine, coming from the ACLU, we care deeply about religious freedom. So there are many conversations about how to draw the lines, how to answer those questions at the beginning about where religious freedom, sort of what its boundaries are. And in essence, we've come to the position, it's a pretty long-standing position within the organization, which is reduced simply. If you're an institution, and I think institutions you can ask very different questions about institutions versus individuals who want to be accommodated. You're one worker in a shop. If you're an institution and you open your doors to the public, you say, come on in. You hire people of different faiths, and you serve people of different faiths, then at some level, you should play by the public rules.
Right.
And it's that principle that sort of drives us to say in these instances, no matter how hot they are, no matter how controversial, no matter what generous emails I received even this morning on this issue, that the question of whether an exemption is appropriate in today's battles are no different from the questions of whether we tolerated exemptions in the context of the civil rights era. We didn't say Piggy Park got an out, so why should Master Bake Shop get an out? So in that context, I'm just going to, because you are ambassadors of the ACLU, and because I'm finding that everybody is not intuitively so always thinking that this is about using religion to discriminate or seeing this, I'm going to walk you through some of the questions that come to me most often and some of the ways of thinking about them. So in the context of the inns, the bake shops, the photography studios, the other places like that, I am besieged by the following questions by, I'll just say, well-intentioned good liberals, which is, why not go somewhere else? Like if there's another inn down the street, what's the issue? Sort of like, do you want to make a federal case of it? Yes. And do you really want to go someplace? Is that where you want to go for your wedding? The place that doesn't want to have you? Like, come on. And it's not meant hostilely. I mean, I sort of can joke about it because I'm among friends. It's not meant hostilely, but when I think about this, and it's said by very good people. When the court was looking at the question of Piggy Park, when the court was considering the question of the barbecue franchise in South Carolina, the question wasn't, is there another barbecue shop within 10 miles? No. The question wasn't, is that really the food you need to have, or could you go somewhere else? By that point in history, we all understood that the notion of ending discrimination couldn't include the idea that you turned people away. It couldn't include the notion that Piggy Park would have, be it express through a sign, or implicit, in essence, a sign that said, whites only for religious reasons. We understood that there was no way that we were going to remedy the discrimination that we were addressing through the Civil Rights Act if we continued to have that. I'm just going to quote from this. There was a case in 1890 when I have a little extra time. I sometimes troll through these old wacky cases for great fun. And this was also a case about a restaurant. This was a case about dividing the restaurant based on the races. It actually would serve African Americans, but over there as opposed to over here. And this court was unusual and sort of striking, saying that segregation was impermissible. And the court said, the man who goes either by himself or with his family to a public place must expect to meet and mingle with all classes of people. He cannot ask to suit his caprice or prejudice or social views that this or that man should be excluded because he does not wish to associate with him. He may draw his social line as closely as he chooses at home or in other private places, but he cannot in a public place carry the privacy of his home with him. So again, that's just a sort of, the same way of saying you open your doors to the public, you play by public rules. And again, do you really want to go someplace that doesn't want to serve you? In my most jaded moments, my response is, it's not that Woolworths had the best food or the best service. There is a principle here, and we understood, we accepted, whether it's looking back now or at that moment, we understood the principle about public accommodations in the context of civil rights, and that the issue of relationships, the issue of ending discrimination against same-sex couples, against LGBT people is no different. So that one, there we go. That's public accommodations. We got that one covered, right? And then the next is contraception. So I was recently at a conference of academics, and it was set up as a sort of debate. And the guy says to me, so Louise, I could probably be with you on LGBT people and the ins. But contraception insurance, really like a federal case, you can't see your way for exemptions in insurance for something like that. And implicit in the question, and he said, women get contraception. Women are getting it now. And so implicit in his question was a couple of things, right? One is the fact if your employer doesn't cover it, it's not the same as banning. It's not a ban, it's like a benefit. It's insurance. And we all know insurance companies mess with us in all different kinds of ways. It's never a perfect system. And it's a service, right? So that was his question. And somebody else at this conference who also said, so these cases that I mentioned, there are cases brought by these institutions and the federal government is the defender. And the federal government is hitting hard to say that requiring somebody to pay for this insurance, to provide this insurance, isn't even a violation of their religious rights because it's too attenuated. You're buying an insurance program so that a woman someday can get the service and then submit to her insurer. And it's not all that different from you're giving a woman a salary and she could go buy. It's attenuated, so it's not a serious violation. And this professor says, the government's hitting hard on that because your argument as to why this service should be mandated isn't that strong. Those are fighting words in my opinion. So here's why I think that. Here's why I think in case. And this one I have to say is a heavier lift, so I'm going to spend a little bit more time. Again, you're ambassadors. I'm hoping you're leaving as ambassadors. So the most basic is contraception is essential to women's equality. Right? I mean, it's almost so obvious that I can't even explain it. So the only thing I can sort of say is just think again about what it's like not to have it. World doesn't look so good for women. Contraception lets us make all sorts of decisions, control, or theoretically control decisions about education, about family, about how we structure our lives. And the Supreme Court in 1992, not necessarily the bastion of feminism, said, the ability of women to participate equally in society, in the economic and social life, has been facilitated by women's ability to control their reproductive lives. So to me, this question about contraception is inexorably tied to questions of gender and sexual equality. 1. 2. There's a really basic way to think about it. If you exclude only contraception from your plan, you're excluding a service needed only by women. So in that sense, it's kind of classic sex discrimination. And for those I sometimes encounter who struggle with this, I sometimes say, so imagine you have an insurance policy that covers everything except Tay-Sachs, for example. Tay-Sachs, a disease almost exclusively falling upon Ashkenazi Jews. Or sickle cell, a disease almost exclusively within the African American community. I don't think people would kind of say, well, it's not a ban, and you can get the service somewhere else, can't you? I mean, so anyway, I'm not so keen on this whole argument that women can get the service somewhere else and that it's not that important. But it goes deeper than that in a more fundamental way that I think a lot of people don't see. I mean, what does it mean to refuse contraception in some sense? It means to say that women, the proper role of women is either to be mothers and accept pregnancies, or not to be sexual beings except for purposes of procreation. Those are the kind of antiquated stereotypes that used to permeate this country and that in a whole different range of ways we've said no to. Right? It used to be that women were excluded from the bar, and the Supreme Court upheld a provision that women could be excluded from the bar in the late 1800s on the ground that the paramount destiny and mission of women is to fulfill the noble and benign office of wife and mother. Women could be presumptively exempt from juries on the ground that, this was the 60s, women is still regarded as the center of home and family life, so we were needed there. Or women could be barred from accessing contraception, also as recently as the 1960s. We have said in those cases that those are roles we can choose to have, but those are not roles that society can impose or say are our proper roles and structure the legal system so as to drive women into those roles. So to create exemptions, to say that companies do not have to provide contraception at some level is reinforcing, or at least supporting, substantiating that kind of view. There's one other way, and I think that people think of contraception as a service, like we're denying women a service, whereas to turn somebody away at the store, to put up what I say in essence, the sign that says heterosexuals only at the bakery or the inn, that's turning people away because of who they are. And for some reason, there's some kind of trip where people can't really understand that contraception is about women. And so there's just one other little analogy I wanted to have, which is, there were cases that went, Bowers versus Hardwick is this sort of nasty case that goes to the United States Supreme Court about the constitutionality of a sodomy law. And the court says there, this is just about conduct. This is about sodomy. This isn't about identity. This isn't about, the term of the day, homosexuals. 15 years later, the court, in striking a sodomy law, sort of reversing itself, the court says, talking about the older decision, the statement discloses the court's own failure to appreciate the extent of the liberty at stake. To say the issue was simply the right to engage in sexual conduct demeans the claim that the individual put forward, just as it would demean a married couple were it to be said that marriage is simply about the right to sexual intercourse. While it's true that the law applies only to conduct, the conduct targeted is conduct that is closely correlated with being a homosexual. The law is targeted at more than conduct. It's targeted toward gay persons as a class. So to treat contraception as just a service and not about women, old-fashioned thinking, or bananas, as I would say. So there you go, down my trip with editorial boards and other people. In sum, when we think about these cases, about this wave that's happening, the questions presented by them aren't, in some sense, whether society should continue to be allowed to discriminate. Right? As I said, we're in Plan B. We're already in a place where we've sort of made that, I think we've really passed that threshold hurdle. The question is, should some individuals with devout religious objections be exempt from those mandates? And I think it just all goes back to these core principles about what are we trying to achieve when we pass a law prohibiting discrimination. And we try to remedy the past discrimination. What are we addressing? Simply stated, I think with all those kinds of laws, what we're trying to address, what we're trying to remedy is a second class status that has been imposed on many of us for many a year. And with that, we're seeking to foster equality, but we're also seeking to end the stigma that's been associated with all that discrimination. And that includes the harm of having the door closed in your face. And that's the harm of having the door closed in your face because of who you love, or how you want to live, or because of the dreams you have for your future. And if those interests are compelling, then I think it means we have to reject the notion that we let any doors be closed in our face. Because otherwise, all we get is a patchwork. And a patchwork just isn't enough.